So the subject of discussion today is professional ethics. I understand this is a topic that is made part of the part 3 of the AOR examination that is scheduled in the middle of the month of December. Some of the enactments relevant to the topic are the Advocates Act 1961 that codifies the legal profession and consolidates the law relating to the legal practitioner. It provides for a constitution of a bar council and the All India Bar. The Bar Council of India rules that have been framed by the Bar Council of India in exercise of its rule-making powers under the Advocates Act is the second statute. Chapter 2 of the rules is dedicated to standards of professional conduct and etiquette. Then come the Supreme Court rules that have been framed by the Supreme Court in exercise of the powers conferred on it under Article 145 of the Constitution of India. Rules have been amended from time to time, as you know, as recently as in 2019, the last amendment took place. Order 4 of the rules with respect to advocates and is relevant. For being registered as an AOR, the eligibility criteria has been fixed in Rule 5. On an advocate undergoing training for 1 year with an advocate on record and on passing the examination held by the Supreme Court, one is entitled to be registered as an AOR. That's the background. I believe it's a tough examination. It needs a whole lot of preparation, and my best wishes to all those who are going to take the exam. For this talk, I shall address you on particular facets of the professional ethics that have been elaborated in Chapter 2 of the Bar Council of India rules. So the focus of my discussion is on A, the duty to the court, B, a duty to the client, C, a duty to the opponent, D, a duty to the colleagues, and I will add 2 more heads, duty to the profession and duty to the public at large. Instead of a bookish discussion of the duties cast on an advocate that I have just mentioned, I propose to take you through a routine working day in the life of a young practicing advocate on record in the Supreme Court and request you to see for yourself the manner in which these duties ought to be discharged. So shall we give this protagonist, the young advocate on record, a name? What would you suggest would be an ideal name? If you agree, we will call him Kartavya, because he owes a lot of duties and it probably fits the bill. Jayant has joined us. That's okay. So I think it would be very nice if you could put away your pens and papers and just enjoy the story as we go along. The lesson is in the story, and I'm sure that you will all carry it with you in your memory. This Kartavya, the protagonist of the AOR narrative, is in his early 30s. He has built a small practice as an office cum residence in Mayur Vihar. Rule 5, Roman 3 of the Supreme Court rules requires an advocate on record to have an office within the radius of 16 kilometers from the courthouse. It's well within that. Kartavya starts getting ready early enough to head for court. His clerk, who is to be mandatorily registered, also arrives on time. The files are bundled into the car and so is the uniform. Mind you, Kartavya does not wear his bands and coat at home. He wears the uniform only on reaching the court complex. Reason? Any guesses? Because the rules of Bar Council expect that the advocate will wear his bands, coats and gown as a uniform only in the court complex and not in public places except on ceremonial occasions. Unlike some of the members of the bar, Kartavya does not flaunt his bands by loosely hanging them on the rear view mirror of his car. for all the world to see. The car sticker purchased from scba is sufficient to identify his car for making an entry into the court complex. Kartavya and his clerk proceed to court well on time, knowing that the heavy traffic flow in Delhi in the early hours and is being aware of the fact that an advocate must be punctual. I highlight that. On reaching the Supreme Court complex and finding a decent parking space, a difficult task today, I believe. When Kartavya wears his uniform, his eyes gleam with pride and his chest puffs up. His neat and tidy appearance adds to his stature. He is conscious of the fact that a shabbily dressed advocate or an advocate wearing a coat with a haphazardly tied soiled band or one wearing a coat and a band with a crumpled gown does not cover the profession with glory. It is a poor first impression of the advocate. By sharp 10 a.m., Kartavya has made his way to court corridors armed with his briefs. He is well aware of the importance of remaining present in court when his case is called out. Knowing that his cases are listed high up in two courts on the same day and there can be a clash with a fair chance that he will be held up in another court, Kartavya takes care to make alternate arrangements by requesting a colleague to ask for a pass over in the other court. Judgments are, as you know, pronounced before the daily cause list is taken up by the court. In one of his cases, judgment is to be pronounced today. Kartavya knows that the decision will go against him in that case. Caught in a bind, what does he do? He skips attending that court and proceeds to focus on the fresh matter. There will be some questions coming up at the end of this talk. To his dismay, the first matter takes longer than he had expected. He is receiving repeated messages from his colleague about the other matter that has already been passed over and is about to be called again by the adjoining court. So what does Kartavya do? He knows he cannot leave the first matter in the midst of the hearing. So he asks the court for permission to leave. And on being granted permission, he proceeds to the other court where the case is about to reach. Here, Kartavya has briefed a senior advocate to argue the matter. His clerk has taken care to place the relevant case law along with the brief in the court and furnish an advance list of citations to the courtmaster for reference of the court. Kartavya discovers that the senior he had engaged is held up in another court, so he's not getting another passover. But as a disciplined lawyer, he is prepared with the brief. He knows his facts. He is aware of the law. He is conscious of the fact that courts do not take kindly to lawyers sauntering into the court with no brief in hand, or when they are blank about the facts in a case, or simply stand up to ask for an adjournment or a passover. When Kartavya's case is called, he takes care to seek prior permission from the court to allow the senior advocate briefed by him to take over from him whenever he comes, and thereafter starts addressing arguments. He notices that his opponent is arguing non-stop in a high pitch and he can hardly get an opportunity to open his case. On questions being posed by the honorable judges, the opposite counsel keeps on trying to speak over the court. This habit is not only annoying, it is most unacceptable. Advocates ought to show the courtesy to his colleagues and refrain from interjecting in the middle of the arguments. This is as much an etiquette as any other etiquette that we read about in the rules. They must patiently wait for their turn to come. Kartavya also gathers an impression that the other side is trying to mislead the court on facts, which is a big no-no. On conclusion of the arguments, the presiding judge starts dictating the order. Realizing that some relevant facts have been overlooked by the court, Kartavya does not immediately jump up to interject the dictation. Instead, he makes a note and waits for the court to finish the dictation. to enable him to point out the facts that according to him had been missed out in the order. The case goes against Kartavya's client, unfortunately. He is disheartened, but he knows that he gave it his best shot. He also knows that he discharged his duty towards his client to the best of his ability. He does not paint a rosy picture to the client